in only English, so that we're not changing languages. Okay.
Ótimo, muito obrigado.
Okay. Good afternoon, or good night, everyone. We are here this evening in the webinar organized by the CJA, the Youth Arbitrators Committee of the CBMA, the Brazilian Center or Brazilian Chamber of Mediation and Arbitration. We are an organization that already has under its members over 400 young attorneys that are interested in arbitration or that are studying arbitration and developing different projects. Today's webinar, we're going to discuss pretty much investment arbitration and the impact of COVID in investment arbitration. Mostly, we're going to talk about substantial law issues, but we will also talk about procedural law issues. We have a Starfield event. First, I'm going to do a brief introduction, and then I'm going to pass the words to my two colleagues who moderate the debates. We have first Alex Wilbraham, who is counsel at Freshfields in the Washington, D.C. office. Alex has extensive experience in investment and commercial arbitration relating to Latin America. His recent experience includes acting as counsel for a mining company in an ICSID arbitration against Colombia and an ICC arbitration concerning one of the largest corporate disputes in Brazilian history. He is fluent in Portuguese and Spanish and has extensive knowledge of Brazilian culture and the Brazilian arbitration market. He's also a good friend who I've shared a couple of happy hours in events and in conferences, and he's a very good colleague. Next is Clovis Trevino. She is a special counsel at Covington and Burlington's International Dispute Practice. She specializes in public international law and international commercial and investment arbitration and represents private entities and states in high-stakes international commercial, investor states, states-to-state proceedings in all sorts of tribunals and institutions, ICSID, ICC, UNCITRAL, and UNCLOS rules, and also before the ICJ, the International Court of Justice. Ms. Trevino is an adjunct professor at the George Washington University Law School, and she has a number of articles and speaks quite often in conferences and elsewhere. We also have with us Guillermo Moro. He's a partner at Guglielmino International Law Firm. He practices law in numerous international investment and commercial arbitration at ICSID, UNCITRAL, ICC, and ad hoc proceedings. He graduated from the Universidad Nacional del Litoral in Argentina, and he's a master's of law from Harvard University. He's also a professor of law, has taught undergrad and graduate courses in different universities. We just have to open a brief parenthesis, especially since I believe that our main public is from Brazil. Guillermo Moro is not a parent to Sergio Moro, just to make it clear. But he, he will be sharing his knowledge on, investment disputes and, his Argentina practice, who is a very special and important player in the investment dispute market in general. To lead these debates, I am very pleased to introduce Orlando and Mateus. Orlando and Mateus are both members of the infrastructure arbitration study group of the CJA, which I am formally the coordinator, but informally I'm just a participant. Orlando is an associate at Tosini Freire Advogados. He's a PhD candidate of international law at University of São Paulo. He's also a CJA ambassador in São Paulo and one of the coordinators with me of the study group on infrastructure and arbitration. Mateus Bastos Oliveira is a foreign associate at Freshfields. And after years of practicing in Brazil with Demaresti, Mateus joined Freshfields in Washington, D.C. He is a Brazilian qualified with an LLM from the University of Virginia. He's also a member of our group, and he's fluent in English, Spanish, and we hope he hasn't lost his Portuguese. Orlando and Mateus, I believe, will speak with a Paulista accent. I've tried pushing them a Carioca accent, but I believe I haven't been successful. I will now invite them to make a brief introduction. Perhaps, Mateus, would you like to begin the debates?
Okay, that's all right. Thank you, Otavio, for this warm introduction.
Mateus, let's just jump in really briefly. I apologize. First, I want to thank every participant for being here today. Thank you for giving us the time to debate. And I also want to make a brief clarification that, every debate here is a debate on academic level, and any of the position that any of our, invitees and any of the participants in this webinar is not of a personal, does not represent the position of, of their clients, of their firms. This is a discussion on an academic level only. Mateus, again, thank you very much. I apologize for interrupting you, and you have the floor. Thank you very much.
No worries, Otavio. Thank you for this warm introduction. I would like to welcome our speakers here as well, and to say I'm grateful for moderating the discussions today with my colleague Orlando. Before we start, as I understand, maybe I'd like to invite our guests to send their questions in our chat on YouTube during the debates. We'll do our best to address these questions during the debates, or if we may, in the end of our discussions tonight. So at this point, it's clear that the pandemic has affected our life in many different ways. One, for example, is that events previously held in person, such as this webinar, are now held remotely. Most of us are working remotely as well. And although it has a lot of advantages, it brings some challenges. In this context, we have seen that countries are experiencing unpredictable and burdensome facts, and are being called not only to protect their citizens from the pandemic, but also to remedy deep economic problems. Needless to say, these events affect foreign investments and investment arbitrations in many aspects. I'm saying this because the main goal of this webinar, as Otavio briefly introduced, is to target some of these issues arising out of the COVID pandemic in relation to foreign investment and investment arbitration in Latin America. We also want to know the opinion of our speakers on how these issues may affect investment arbitrations in the future, in what we call the post-COVID world, a moment that, of course, we are all looking forward to. So, to set the grounds of our conversation, I would like to invite our panelists to comment briefly, if possible, about the last 20 years of investment treaties and investment arbitration in Latin America. Alex, perhaps you can start, but please, Guillermo and Clovis, feel free to jump in whenever you would like.
Okay, thank you very much to CBMA and Otávio, Mateus, Orlando, Guillermo, Clovis, and everyone for the kind invitation to speak. So the modern world of bilateral investment treaty arbitration goes back to the late 80s and early 90s. In Latin America, the big wave of arbitrations really starts off with the Argentine crisis at the turn of the century, when Argentina, having done a lot to aggressively encourage investment in foreign investment in Argentina, having signed and ratified a lot of bilateral investment treaties, then faces a currency crisis, particularly caused by the fact that the Argentine peso was pegged to the US dollar. They'd given guarantees that various enterprises, for example, in the gas supply industry or the water and sewage industries who invested would be able to charge tariffs in hard currency or pesos that were linked one-to-one to the dollar. When that all fell apart in the crisis of 2001, 2002, there measures were taken which affected many investors and led to a lot of arbitrations under bilateral investment treaties. Not long after that, you then have situations arising in Bolivia and Venezuela. Venezuela, the Chavez regime, Bolivia, the Morales regimes took a position that was more left-wing. There were a lot of expropriations, and various issues arose in terms of expropriations and valuations of companies at that time because of the actions of the Chavez regime and the Evo Morales regime. They were, to a degree, and I'm grossly generalizing, I have to say here, the Bolivia and Venezuela cases were more focused on expropriations. The Argentina cases looked more closely at issues such as indirect expropriation. And later on, you've had other countries having arbitrations under BITs, including Colombia more recently, which involve regulatory measures or allegedly inconsistent measures taken by different arms of the government or the judiciary that have allegedly caused breaches in treaties. If you go further in Latin America, north to Mexico, you have a wave of cases also, or a number of cases involving Mexico under NAFTA, Mexico and the United States and Canada. What has all of this led to? Well, it has led to, some would criticize the whole regime. There has been criticism of the whole BIT system, arguing that it overprotects investments, that it allows litigants or claimants to go forum shopping by investing in countries with through vehicle companies or through subsidiaries that are based in countries with better treaties and treaty agreements with the countries into which they're investing than their own country has negotiated with the target investment country or the place where they're investing. Perhaps the most contentious issue that comes up, or criticism that's often made, is that bilateral investment treaties and the fact that the right to take action for a claimant, that is to say an investor, a company, to start an arbitration directly against a state without having to have its own government of its host country being involved in that, because they have triggered these arbitrations and started these arbitrations, this has become, goes the argument, a disincentive to states to do things like to regulate. It prevents them from regulating, you'll even hear people saying. In actual fact, no treaty will prevent you from regulating, or prevent governments from regulating, or indeed from expropriating or taking most of the kind of actions that they have a sovereign right to take. The real question is, what are the consequences, and how can a person affected by those consequences take action against the state? Do they have a direct right of action, as bilateral investment treaties very commonly do give them, or must they go through their own government in state-to-state dispute resolution? Investor-state dispute resolution, the modern bilateral investment treaty model, in most cases, although Brazil is an exception, and we will come on to that in a second, because they follow that model, it means that because claimants are proactive, they are the ones who have led to an increase in the number of arbitrations. It's a natural consequence of that. But it is important to remember that treaties do not prevent states from expropriating, provided that they provide adequate and prompt compensation. And these are usually standards that you will find expressly identified in a treaty, along with other standards. It's perhaps helpful if I briefly outline what they are, just to remind us. It's usually a bilateral investment treaty will guarantee national treatment. That's to say that an investor will be treated no worse than and given the same rights as a national of the country into which they're investing. Most favored nation clauses mean that you get the same treatment as a foreign investor in that country will get, that they won't be preferred over you as an investor. Protection against expropriation, which is the most commonly known about and thought about aspect of bilateral investment treaties, but also indirect expropriation. The government cannot take measures that effectively amount to or are tantamount to an expropriation. And in the Argentine cases, you very often saw more subtle types of state action that were arguably amounted to an expropriation, because effectively you can't make money out of an investment if the entire tariff regime, for example, on which it was based, is taken apart by the state. So went many of the arguments in the Argentine cases. Perhaps even more importantly, the treaties commonly guarantee fair and equitable treatment. And fair and equitable treatment has come to be one of the most commonly used clauses in bilateral investment treaties. It is also, usually because it is more flexible as a standard, that has become the way in which, for example, many of the Argentine cases were decided not on the basis of indirect expropriation, but on the basis of the fact that there was a breach of the fair and equitable treatment standard in a given treaty. And this is because the modern international law, and particularly as it has developed through various bilateral investment treaty cases applying these treaties, has come to the meaning of fair and equitable treatment. It is constantly argued about, and so don't take my definition as being the be-all and end-all, the everything of this, but it includes concepts such as the modern concept, includes legitimate expectations, in other words, that an investor, if they were provided with reasons to believe, guarantees of certain kinds, that if they invested, then there would be a particular regime would apply, etc., to their investment, then states cannot breach those legitimate expectations. Obviously, I'm simplifying a lot in summarizing that argument. Guarantees of due process. States must also cannot act without transparency. So the concept of fair and equitable treatment includes the notion of transparency. States cannot coerce or harass or engage in abuses of power or bad faith. And they can also not engage in arbitrary, discriminatory, or inconsistent treatment. This has been because fair and equitable treatment, FET as it's often called, has been the basis for many decisions in favor of investors and against states. States have often looked in negotiating a new generation of treaties. There's been a kind of arms race where states have said, right, well, since we've had these unfavorable decisions against, say, Argentina or Venezuela or Bolivia, we will negotiate treaties that are more restrictive. And so states have sought to restrict the way in which the wordings of treaties define certain things. So the notion of investors is more narrowly defined. So, for example, to exclude mere shell companies treaties will impose requirements on what's required to be an investor from a given state. You must have, for example, a substantial business presence, that kind of thing. There have also been attempts to narrow the concept of fair and equitable treatment, to take it back, to dial it back to what's called the minimum standard under international law, going back to a very basic test applied nearly 100 years ago in the NIA case, the NIA versus Mexico, where fair and equitable treatment was defined in that case as being something very extreme. Essentially, it was egregious, outrageous, shocking, or otherwise extraordinary behavior. But that's not ended things, because of course there is still a debate about whether international law and the customary international law concept of fair and equitable treatment has broadened to include concepts such as legitimate expectations, or whether when, for example, NAFTA talks about restricting things just to the concept of fair and equitable treatment, just to the international standard, the customary international law standard, whether that means that it's only restricting fair and equitable treatment to really bad behavior, outrageous, shocking, otherwise extraordinary. And that is a debate that is still up in the air. States have also tried to narrow things to include carve-outs for tax regulations, or for environment, or for health reasons. So, for example, again, what we have to remember here is that it's not that the treaties are preventing states from taking measures, for example, for passing tax laws, or from passing environmental laws, or from passing laws about public health or human rights. The question is, if a state takes an action that involves, for example, the environment, it passes a new environmental law that means that a mine that was into which an investor invested a lot of money at a time when environmental law said X is permitted, if the government changes its law to say X is no longer permitted, does that mean that they must pay compensation because there was a legitimate expectation? And states have tried with a more recent wave of treaties to apply more restrictive wording. Nonetheless, there is usually, you'll find if you look at these clauses, the argument doesn't end there, because there are requirements for such actions not to be discriminatory. In other words, you can't pass an environmental law that is tailored specifically to exclude that mine, because politically it's become unpopular, and therefore you pass a law that says mines in the area of, and you define it so that it just covers one particular mine, and that may allow other mining enterprises to continue. That kind of thing could, for example, be described as discriminatory. And also many treaties will also have wordings that require things, environmental measure, to be proportionate. In other words, it cannot, the state cannot swing from being quite permissive in one at the time an investment is made, and then suddenly go to the other extreme in a disproportionate way and say, ban all mining all of a sudden everywhere in the country, when previously the regime was that if you applied for and justified getting an environmental permit for that project, going through all the hoops that the state's that law as it then applied required, you would be entitled to build a mine if it satisfied those laws. So those are some of the things that have been happening over the last 20 years. It's a very, very brief history, but I've spoken for too long, so I'll hand over to Clovis or to Guillermo. I'll let Mateus choose who speaks next.
Actually, no, please, Clovis, Guillermo, please provide us your remarks on about this history and these facts of investment arbitration, as you will.
I can go, Clovis, but of course, please go first if you want.
Feel free to comment first. Thank you.
No, thank you. Fantastic. Well, thanks to, first of all, Orlando, Octavio, and Mateus for putting this together, and to everyone on the other side, as it were. We're all on the other side here, but attending this meeting. And thanks also to Alex for this very interesting introduction and overview of the events during the last 20 years international investment regime. or international investment protection regime. I would just perhaps just take two issues from what Alex was pointing to, which I think might be of some interest. First is, Alex was saying quite correctly that international investment arbitration, as we know it, begins basically with the Argentine cases at the beginning of the century, or arising out of the events in Argentina at the beginning of the century. And that is in itself a remarkable fact if we take into account that the treaties, such as the ones that were invoked in those cases, date back decades ago, decades to the past, more precisely. That is to the late 50s, if we take, as it's usually done, the Pakistan, Germany, BAT, or to the late 60s, if we take the Netherlands treaties and really consider that the investment treaties, as we know them, begin with those treaties that, unlike the Germany, Pakistan, BAT, contain an ISDS clause, that is, a clause that allows investors to sue states rather than some kind of state-state dispute, which is more or less a continuation of what the protection, the diplomatic protection, international general law was provided in the past. So what this tells us, well, perhaps this fact tells us several things, but one of the things that this tells us is that the development of the regime depended of the interpretations that were developed in the context of disputes. That is not that much the texts of the treaties, which actually turned into the actual or the current regime, but rather the construction of the meaning of those treaties as resulted from parties arguing those cases and then from several different tribunals rendering different decisions. And so this is interesting also for several reasons, among them the fact that states, one could say, ended up actually grasping what they had signed to in subscribing those BATs after the fact of those awards were now becoming public. Of course, this is something that one could say of all legislation, both local and international, that contemplates some sort of adjudication. But I think it's particularly it's a particular feature of international investment arbitration, taking into account that basically those first generation treaties, as Kenneth van der Velde would have it, were very succinct. So they have like 2-3 pages, few very general protections, and which of course nobody could be against. Alex was mentioning the fair and equitable treatment, providing fair and equitable treatment to investors, or perhaps not incurring into arbitrary measures or non-discrimination. But those very general remarks, those very general provisions, ended up having very concrete and in many times impossible to anticipate consequences for states. And this is problematic, I think, in terms of what the objective of these BITs were and still is. On the one hand, one could link that purpose to the attraction of foreign direct investment flows, and that is, of course, a very disputed issue. And we perhaps might go back to that if we go to the Brazil case afterwards, or at any other point in time, because there's a bundle of very interesting empirical literature on the topic. But there's another purpose of the bilateral investment treaties was to, as it were, bring good governance to those states subscribing them, right? And that is quite hard to get. This goes to Alex's point of the, as sometimes has been called, the chilling effect of BITs. That is the effect of states preventing themselves from adopting otherwise desirable regulations because of the fear of facing then a multi-millionaire suit against them. So the point that I'm trying to raise here is that states for decades have not been able to really know and then being able to be properly motivated towards that end by those treaties, because what they actually meant only turned out to be clarified, if at all, after the fact, as it were. And that is particularly true, I think, of those early cases of Argentina and the first decade of the 21st century. I think it can also be said to be true now, more than 20 years after the fact, but certainly was the case in those early cases. And I think that's a quite remarkable and specific trait of international investment arbitration, as we know it. And the second and last point I wanted to add from the Alex's presentation, to complement Alex's presentation, as it were, is what are the respondent states? Because it is true that those states adopting more, as it were, left-oriented policies that were certainly very present in the debate in Latin America in the 60s and 70s, in the new economic order movement, and in the resistance that Latin American states, all of them, had at the time to be included in the international investment regime. Brazil was not alone at the time. It was joined by all other countries of the continent in not subscribing the exit convention, in not subscribing to bilateral investment treaties with ISDS provisions. And so those states that still go to adopt policies such as direct expropriation and want to discuss whether or not compensation is mandatory, or the conditions and the promptness of their payment, the amount, well, of course, they can be reached by these provisions in treaties. But a quite, again, remarkable development is that the respondent states are not only, and I would say they are less and less mainly, the left-oriented or socialist countries, but all states around the globe. And this is a movement that we are contemplating right now in the region and across the globe. So you can have dozens of cases against Argentina for the measures adopted in the context of the crisis of 2001, and then against Venezuela during the presidency of Hugo Chavez, and then also against Bolivia during the presidency of Evo Morales. But you can find also dozens of cases against, say, because it was mentioned before, Colombia in the continent, or Guatemala, or Mexico, irrespective of the orientation of the government. And in Europe, we are seeing the same trend towards Spain, towards Italy. And then the first arbitrations against Norway, Denmark, countries which were thought to be possibly only present in international investment regime as country of nationality of investors. And now they are becoming also respondent states. And this is, again, arising out of the very extensive interpretation and construction that over the years, tribunals, and with the assistance of lawyers and academics, have developed of those very general provisions in treaties. And so then we can discuss, well, what can you do about that? And I think that I will address that issue later in terms of treaty making and treaty negotiation and treaty interpretation. But for now, I think it is important for us to take into account that this construction of what a treaty is, that goes beyond the text of the treaty and into the tribunals that actually interpret and construct what they are, has led to a very extensive construction of the protections that eventually has had the states that were unthinkable as respondent states being respondent states, and these protections going all around the world, the globe, for all kinds of very different situations that foreign investors can face.
Thank you, Guillermo. Very interesting that you mentioned this stages and development of bilateral international investment treaties, and the situation of Brazil, which is quite particular in this world. So basically, in summary, differently from other countries in Latin America, Brazil joined the BIT's movement in the 90s. The country did sign some BITs, but none of them became enforceable since they were not internalized by Brazilian Congress. On the other hand, in the last few years, Brazil signed new investment agreements, as we know, called the Cooperation and Facilitation investment agreements, which, however, are quite different from even from the modern BITs that we are just talking about. Alex, if I may ask you, I think the question about Brazil is, where is Brazil situated right now in regard to, let's say, the Latin America BIT club?
Thank you, Mateus. Well, I think Brazil is really located outside it. Brazil has taken the view that though it signed various treaties in, I think, the 1990s, it has not ratified them. I think that the Argentine effect on Brazil that coincided with the change in government from Fernando Henrique Cardoso's government to the PT government was something that that's one factor. There are many other factors, and I don't pretend to know all of them. I'm just speculating, really. Caused Brazil to look at Argentina and go, maybe we don't want to get into this. Maybe we don't need to get into this. It's very difficult to say whether Brazil, if you look at the figures, Brazil has continued to be a place that attracts a lot of investment throughout this period. Was that because it didn't have treaties? Would it have got more, rather, investment if it had ratified those treaties? It's a difficult question to ask. It may simply be that Brazil was the largest economy in South America, and for that reason, it was the place with the largest number of consumers, etc., that people really wanted to be. That's possible. Guillermo talked about the chilling effect of seeing decisions against states realizing that there were consequences of signing treaties. I think that in terms of Brazil, I think you could point to Brazil as being a country that said, we don't want to have all of that trouble. That said, I don't think Brazil would have had, if I asked myself, how many cases would Brazil have had in the last 20 years? It would not have had a wave of cases like Argentina, because it did not take the same approach, even though it's had various, perhaps less serious crises than Argentina. There would have been some cases, I would imagine, but nothing like the wave of cases that Argentina had. Nonetheless, Brazil decided that it did not want to get into that. The chilling effect can sometimes be applied to smaller countries for whom it's costly to defend against arbitrations. That said, as a whole, across the whole of Latin America, I'm not sure if the chilling effect is something, if balanced against the fact that investors have seen that it is possible to defend their investments using this effectively new tool, new as of the 1990s, whether that is something that caused them to invest more as a whole. Again, it's quite a difficult question to answer. But one thing I think that, and again, picking up on something that Guillermo said, that Brazil misses out on is the consistency effect. Because precisely these issues such as what does it mean? What do legitimate expectations mean in the context of international law relating to investments, fair and equitable treatment? What is an indirect expropriation? What kind of measures are arbitrary? What kind of measures are not transparent? Over the years, a jurisprudence has emerged, and it is still emerging, and it will continue to emerge as countries adjust, for example, the process of adjusting and drafting new treaties and refining how these concepts are defined. There is now a far more comprehensive body of jurisprudence about what these things mean. And because capital moves around the world and can choose where it goes, this evolution of international law in relation to investments and what these concepts mean, I think is important. It is helpful for investors to know. And even though countries don't often like it when they face cases, it does allow them, it gives them some kind of transparency on how to build a regime that is less likely to end up in negative awards against them. And often these cases, for example, countries around the world facing cases, Denmark or countries that normally didn't face them before, These are all part of life, I would suggest. They are part of, it doesn't necessarily mean that they will be subject to a whole wave of awards against them, but it means that those countries too are engaged in this process. They need to think about what their measures mean, what effects they might have under international law, and what effects that actions might have on investors. For Brazil, I think Brazil has taken small steps, baby steps more recently, to try to engage in a process which is not effectively investor-state dispute settlement, but through agreements that it has with various countries, particularly in Africa. I think only one of them, the one with Angola, called the Cooperation and Facilitation Investment Agreements, is actually in force. That requires state-to-state dispute settlement. How that will work exactly in practice, I don't know, because of course it leaves the decision-making about whether to start a claim in the hands of the state rather than the investor, and that is the big attraction for companies, investors of this whole investor-state dispute settlement mechanism. It gives them more control, and that is, I think, one of the primary comforts to the investor of that regime. What is protected under the CFIAs, as I understand it, is a much more limited range of issues. National treatment, most favored nation treatment, and direct expropriation, those are protected. And therefore, in theory, if Brazil as a country is prepared to stand up and defend a national who has invested in this case, Angola, if there is an expropriation or if there is treatment of an Angolan national company that is overly favorable and that is unfavorable or discriminatory towards a Brazilian company, well, in theory, they could take action. But it does leave out very important other protections like indirect expropriation and fair and equitable treatment. And those are often the things that states will do. They will engage in, they will take measures that are effectively indirectly expropriating an enterprise, or that are not transparent, or that breach legitimate expectations. And in those circumstances, investors, Brazilian investors, and there are large Brazilian investors now, because Brazil is now becoming a capital exporting country. Companies like Vale do Rio Doce and so on are investing in Africa and the rest of Latin America. And unless they go through other countries that do have treaty protection, if they were to rely only on the CFIAs, they would not be protected if there was an attempt, say, by the Angolan government to effectively change a tariff regime, for example, in such a way that the business becomes completely economically unviable. An indirect expropriation, you might say, or also arguably a breach of a fair and equitable treatment standard, and they would not be protected. So I don't think Brazil's capital exporters are particularly protected by these CFIAs, and I don't think that the absence of the investor's ability to choose when and if it believes it has a claim. And investors, let's face it, they must also invest a lot of money in these claims. So it's not just the states who are on the receiving end of these claims. If you lose a claim, then there's a cost risk and so on and so forth. But it takes that freedom out of the hands of investors, and that I would suggest can be a disincentive. Though reading the minds of investors on this point, I don't pretend that I can. You can only speculate about what might motivate them. But I do think that likely is a key motivator.
Thank you, Alex. Yeah, indeed, the experience with in regard to Brazil has been quite speculative. Once we don't have none of these investment agreements have been really enforced in practice, right? And Clovis, I'm sorry I handed back to Alex just to take the opportunity of Guillermo's comments about Brazil and the experience of Argentina. But would you like to add anything further on this point before we move to our other questions?
Thank you for the very interesting background and the conversation we have had thus far, and thank you for the invitation, and to Octavio for the introduction. My plan for my intervention was really to comment on how COVID-19 fits within this background that we have heard. So I have no further comments and would welcome the opportunity to comment on how the crisis or the pandemic that we're facing really fits against this backdrop of PITs and the law and the investment law that has come to develop throughout the years.
Perfect. So with that, I will hand over to Orlando because I believe he has a question exactly about that.
Yeah.
Thank you.
Mateus, let me jump in. There is a question in YouTube from Pedro Henrique Junqueira, which I believe is related to this topic, especially related to Brazil's participation in investment arbitrations. And this is quite interesting because we are having a discussion of, Brazil's participation in investment disputes. And, as Alex said, where would Brazil be in, this span of disputes that arise during the Argentine crisis, in a period where we're actually seeing news coming out in the newspaper almost daily of, a state or municipalities expropriating or, canceling concessions to private parties. Maybe in a foreign context, this could entail, an exit tribunal. And I believe this is where Pedro Henrique Junqueira question may come in. Pedro asks the following questions. A number of Brazilian companies have investments outside of Brazil that have, one way or the other, faced challenges. None of these challenges have been discussed in investment arbitration proceedings, even when it could have been. Why would you consider that to be the case? Guillermo, Alex, or Claudius, do you have any, any opinions on why perhaps it could have been the case?
Well, why could, if I understand the question correctly, then why could such issues have been discussed? I think there are ways in which Brazilian companies, if they'd invested, for example, in other countries through countries with treaty protection, then you could have had a Brazilian company involved in a bilateral investment treaty arbitration where particular issues, usually the same or similar issues about changes in tariff regimes or whether a particular, sudden new windfall tax or whether an expropriation or whatever was somehow a breach of a treaty. I think you could have had that. I think it is what I find helpful in arbitration is the fact that we have this international language of bilateral investment treaty law has helped illuminate many areas, technical areas. For example, in the electricity industry, you don't have that many cases. There will be cases in Brazilian courts where there is a tariff, there is a concession, there is an issue that comes up. But very often, a lot of the major issues that come up in, for example, solar energy, it comes up in many countries. Spain, because it became a target for claims because it had an incentive regime creating expectations that it then changed quite drastically because there was a problem. And that's created a wave of cases that we can look at and go, well, what does a legitimate expectation mean when you're talking about an incentive regime for alternative energy, for wind power, for example? Brazil has these projects, and you have other problems, other countries which have done similar things where similar issues are coming up. Brazil, I think, by not participating in this world, it leaves that case law somewhat orphan. Is it relevant in Brazil? For example, if there is a similar measure to the Spanish measure is taken by the Brazilian government, would that concept apply? Would Brazilian law import this concept of international law? I know it doesn't apply it as an article of Brazilian law, but for example, what does it mean to be transparent about a particular type of incentive regime in a particular area, an industrial area. There are a lot of very good technical cases that go in both directions, that establish limits where states have won and states have lost. And I think Brazil, to a degree, loses out by not participating in that process and making the law. There is an argument, though, that the other side of the argument, perhaps someone else will make it, would say Brazil dodged a bullet by not being involved in all of that. So, you know, you can take your pick, you can take your position on that one. But I think Brazil, to a degree, loses out by not being involved in that debate, because capital is international, and just as other things like concepts of competition law, for example, you can't really today make a competition law regime that ignores the rest of the world. You do need to follow certain standards, because that's how the world works. Even if you make adjustments for your own national state and how things are in your own country. I think there is an argument that says it's good to be part of the system and to contribute to it.
Just if I may jump in where Alex left off, just a very brief comment. I think that is a very interesting point, the one of the language, how the construction of a common shared language contributes to some kind of foreseeability, both for investors and states. I would only add that maybe just raising a question mark whether Brazil is actually outside of the regime, or whether at least a different, perhaps better, I don't know, but a different way to put it would be to say that Brazil plays within the system, but differently. And so in that regard, I think that these acuerdos de cooperación are very interesting, irrespective of whether we share or not the actual decisions in terms of regulation. Some of the more remarkable ones are, for instance, the express exclusion of what is called like desapropriação indirecta, and the restriction to the direct expropriation in terms of protection for expropriation, and also, of course, the very peculiar system drafted to administer disputes, which do not accept investor-state stages of dispute, but it ends up being a state-state dispute at the end of the day, if at all. So even whether we have an argument that this is a good or a bad decision policy-wise, even whatever our opinion on the impact of these kinds of regulations on economic attraction of foreign direct investment flows, I think Brazil represents, perhaps is the only country in the world that represents a different way of participating within the system from an institutional design perspective. And this is something that I think is quite valuable to retain. Because these acuerdos, these treaties are treaties. They contain provisions that protect investors. They contain a very detailed process of accompanying and administering disputes at the early stages. And what they do not contain are some of the typical protections, and then the typical way to resolve those by investor-state disputes. So I think that particularly in the context of the working group 3 of UNCITRAL and the actual discussion over the reform of the investor-state protection regime, not to consider Brazil as being outside the system, but to consider Brazil as being within but differently. I think that I would suggest that is the way I think I look at it. Because, and this is very remarkable, and if Octavio, Orlando, and Matheus grant me just a minute to go into the anecdotal, but well, all of ourselves, which are fans of what we do here, we do things such as listening to the audios of the meetings at Untittled, which are publicly accessible at the website. And I recall, I think this was the third or fourth meeting of the group. In the first session of the first day, there was an intervention by the Brazilian representatives, and they handed out a brief with the Brazilian way of doing it, way of going around it. At least from what we can hear, it went completely sort of unnoticed. They just handed the brief, well, it was received, and then the discussion went for 5 days in a different direction. And I think that is rather unfortunate. Not that I am advocating the Brazilian way, but I think that Brazil stands for institutional imagination in the face of designing the actual legal protection for transnational investments, allowing us to ask questions that the actual mainstream design of VITs seems to cancel. So that's just my 2 cents on Brazil in this instance.
Perfect.
Yeah, I like Guillermo's framing about Brazil being a player, but a different type of player. And correct me if I'm wrong, the Brazilians would certainly know more than I do on this topic, but as I understand it, there is a significant number of commercial arbitration cases in Brazil, and I understand that the state itself and state entities do enter into state contracts in the traditional sense of the word. So that builds on the idea that Brazil does play into the system, just in different terms.
Yes, and I'd like to make a quick comment on this. I also find this idea of Brazil playing differently kind of interesting, as Brazilian companies are well aware of the system of investment arbitration. Even state-owned companies like Petrobras. Petrobras has also investment arbitration through the Netherlands BITs, sort of like this. So Brazil knows this game, knows how to play, and plays differently. And it is quite interesting. Okay.
Yeah, Orlando, you want to just pick up and,
Okay.
rate the COVID-19?
Yeah. Great. Okay, so moving on to the next subject, that is specifically to discuss this issue of the global health crisis, the pandemic, in this investment system. As you are well aware, most states, I believe, and obviously also Latin American states, they have adopted some measures to protect public health, such as restricting mobility for its inhabitants, suspending or shut down business considered non-essential, among other measures. And although they may be suitable to answer to the pandemic, they also might have some crippling effects on the interest of foreign investors. And to discuss this issue, actually, I'd like to give this floor initially to Ms. Clovis Trevino to open our conversation. And we even already have some questions on this issue that I'll address it after our initial discussions. So please, Ms. Clovis Trevino.
Thank you, Orlando, and thank you everyone who's joining via YouTube. I want to touch on how COVID-19 fits within this framework of dispute resolution that has come about in the past years. So, as Orlando mentioned, and as we all know, in response to COVID-19, states have undertaken what I would call unprecedented measures. We're speaking about travel bans, lockdowns, closures of non-essential businesses, and many states have even taken over private assets in the context of the pandemic. For example, private hospitals were nationalized in Spain, medical masks were seized by France, and even the United States reluctantly compelled companies to manufacture ventilators. This is quite unprecedented, and this is really a juncture, I think, in investment treaty law. How are states responding to the pandemic, and how will the investment arbitration system adapt to this new reality that COVID-19 has brought about. So, states facing legal claims in the context of COVID-19 related measures will likely argue, as we have heard already, that they have not only a duty, but also a right to protect the public health of their citizens. And international law does recognize certain latitude to states to do so, to protect their citizens. We have treaties that, for example, provide that non-discriminatory measures adopted for the public health cannot give rise to investment treaty claims. We have other treaties, such as CETA, that expressly contemplate the state's right to regulate to achieve legitimate policy objectives. And even in the absence of treaty language, states are capable of invoking the so-called police powers. You will all recall, for example, that in Philip Morris versus Uruguay, the tribunal found that certain anti-smoking measures adopted by Uruguay were a valid exercise of police powers. So, in the context of COVID-19, states can also seek to invoke exceptions to liability. We already heard about the Argentina cases from Alex and from Guillermo. And as you may recall, Argentina invoked the so-called necessity exception when measures that would otherwise violate a treaty are taken to safeguard what is referred to as an essential state interest. So Argentina invoked the necessity defense. We have case law adopting Argentina's arguments, but we also have cases that reject this exception and simply hold Argentina liable for damages in the context of the 2000 economic crisis. So the bottom line is that the latitude of a state to respond to COVID-19 is not unlimited. As Alex also mentioned earlier, measures that are adopted in bad faith that somehow deprive investors of due process, that nationalize or expropriate companies without compensation, or perhaps in contravention of an investor's legitimate expectations, may give rise to state liability. So where do we draw the line? Where do we draw the line between legitimate responses to a pandemic that has upended life as we know it, and the protection of investors and their investments in accordance with international law and bilateral investment treaties? This is an interesting new topic, but we do have the backdrop of the Argentina cases to give it some framework and to fit within that framework the responses that states are taking and will be taking to the effects of COVID-19. And I, of course, welcome the view of my panelists, Alex and Guillermo, on how they envision the future in this new reality that COVID-19 has brought about.
If any of you want to join the discussion, please feel free.
Where do we draw the line between legitimate measures to safeguard public health and abuse of the crisis to undertake what would otherwise be considered measures in violation of international law? Well,
I would suggest there's the places that you look usually, and where they looked in the Argentine cases, what does the actual treaty say? And then more broadly in international law, they looked at the International Law Commission's draft articles on state responsibility, and particularly Article 25 on necessity. There are reasons why states can take certain measures that would otherwise breach international law. For example, self-defense was always one of them. If someone attacks you and there's a war and blah, blah, blah. The state of necessity in Article 25 is defined as a way that allows a state to safeguard an essential interest against a grave and imminent peril, and does not necessarily impair an essential interest of the state towards which the obligation exists, or the international community as a whole. But they can't do this, they can't invoke it, the article goes on to say, if the international obligation in question excludes the possibility of invoking necessity. So if there is a treaty that says you can't invoke necessity, or if the state has contributed to the situation of necessity. So if in taking a measure you make it worse, in other words, I don't know, I'm guessing, but you know, if you suddenly do something that is going to make something really bad, worse than it was before, and then you impose a measure on somebody that is actually brought about by you or the state's irresponsibility, then that could be precluded. That would be outside the state of necessity in Article 25. Plus, don't forget that there is Article 27 of the draft articles on state responsibility, which says that the invocation of a circumstance invoked precluding wrongfulness, including Article 25, without prejudice to compliance with the obligation in question, if and to the extent the circumstance precluding the wrongfulness no longer exists, and also the question of compensation for any material loss caused by the act in question. And these are the key points, really. First of all, for how long will that situation last? A government that takes a measure that says, look, right now, you've got to produce masks or something for the next 3 months. Well, that's, you know, they have police powers. They could argue that it's necessity. Arguably, they could bring that argument. But for how long does it need to carry on? That's the first question. Secondly, does it preclude compensation? This was a big argument in the Argentine cases, and that there isn't really a completely, absolutely clear, this is the law and this is the way it stands, answer to all of those questions, because the cases go either way, and on that point. You know, people can still, it's still open to argue that, you know, certainly once the situation is over, you can't just say, oh, well, since we, you know, expropriated your factory to make masks, well, carry on making masks. And I want to go back to making fridges or whatever it was I was making. And then the question of compensation, even for the period, even if they follow the I think is a clear rule in my view, that an emergency lasts as long as it reasonably lasts. It's not going to last for 5 years. I mean, inshallah, I hope not.
That's a scary thought.
But, you know, at some point it will end. When? Well, there will be cases about this, I'm sure. So I don't want to nail myself down to a particular view as to what the definition is of when it ends, but it will end. And at that point, it's over. Is the state obligated to compensate for that period? You'll need to look at the treaties that apply, because if the treaty has an adequate carve-out, if it's a treaty of the certain treaties will preclude, you know, will be very clear about the police powers doctrine. They'll enunciate it in a specific way that would allow them to say, I'm sorry, I'm not going to compensate you because I don't have to, because this was a measure for public protection of public health. Alternatively, if there is no specificity on that, then arguably it would be open to argue that then, even for the period of emergency, which if it's agreed when that period genuinely was there and that it was a genuine invocation of the doctrine of necessity, the question of compensation for that period still arises. And there is jurisprudence in the Argentine cases that points in both directions, if you like, on that point. And so in each case, you need to look at the treaty, look at the circumstances, and always governments must act reasonably. And you must think, just as when you expropriate, you think, well, do I need to do this? Is it proportional? Is it necessary? And then the question of compensation arises, and whether or not there should or should not be compensation will often depend upon the treaty itself. That Guillermo perhaps has something else to say on that point. I don't know.
Thanks a lot, Alex, for that intervention. Again, very, very interesting, and also Chloe's for setting the stage briefly and precisely, both virtues. And so just adding 2 points. One is that another element typically in the analysis, and this analysis goes both to a difference of police powers and a difference of necessity, which are different. And we have to have that in mind, because when you are talking about necessity, you are talking about as constructed, as Alex was pointing correctly, at under Article 25 of the draft of the ILC articles, which are understood to be international customary law, but now, by now, it's relatively unexplored at the moment. It's a circumstance precluding wrongfulness, right? So your starting point is that it's a breach of international law, which can be precluded if the very specific circumstances and conditions envisioned by Article 25 or crystallized in Article 25 are met. But then the police powers, the so-called police powers defense, or the regulatory powers exercise of the state have different outlook to it, and it speaks to actually one of the last points that Alex was touching upon, which is the compensation. So if you have actually good faith, non-discriminatory, non-arbitrary exercise of the right to regulate, then there's no breach. Then there's and also there's no right to be compensated on the part of those who have been lessened in any way economically as an effect of the adoption of those measures. So those are two different ways to get into the discussion, even though they have some techniques that overlapping. And one of those techniques, which is the second and last one I wanted to add, is the proportionality analysis, which is shared, but again, differently unfolded in these two lines of legal analysis. And so proportionality has been a tool that has been increasingly taken up in international investment arbitration. Quite interestingly, briefly put, it has entered international arbitration from two different avenues. One is the avenue of international public law, mainly proportionality as constructed in international tribunals, including the ICJ in criminal cases and in war circumstances, which is a very sort of rule of thumb way of looking at proportionality. And then a very different avenue, which is local administrative and constitutional law in the Western world, which has a quite more precise threefold proportionality analysis that goes into the legitimacy of the ends pursued first, then as to the necessity, meaning the measure being the only or at least the less harmful for the affected individuals, and then what at times has been deemed or called proportionality stricto sensu, that is the actual balancing exercise between the two or more issues at stake. And so this has led to a sort of hybridation within international investment decisions. You can find decisions, for instance, as Occidental v. Ecuador, the second Occidental, the Oxy 2 case, as we typically call it, which has which takes a public law issue, which should have been analyzed under the threefold test that I was just mentioning, but it gets analyzed more in the rule of thumb way of the traditional international criminal law, meaning, well, there was another alternative, this was not really proportional, then there was a breach. It's quite remarkable because that is it was for a few years the largest award against a state, more than 2 billion years before it was partially annulled. And I think it's a 300, 400 pages award, but the core of the merits decision is just 3-4 pages on proportionality. And then you have more recent decisions, such as the one you were mentioning also, Clovis, that Philip Morris v. Uruguay, where you have a more detailed, more like the administrative law test, threefold test of proportionality. So that is, I think, up for grabs now. It depends on the tribunal, on the case, but that is, I think, a technique that's quite important to draw the line in terms of what is a legitimate, lawful exercise of regulatory powers and what is perhaps an unlawful one. I think proportionality would play out quite largely in that analysis.
Is there room for force majeure in this analysis in the terms of Article 23 of the ILC articles? I welcome thoughts. I do not know the answer.
Go ahead, Alex, go ahead.
Well, I think force majeure is a concept that is, as you say, it's recognized in international law. I think that it is generally more commonly applied and understood in terms of contractual relationships. I think that it depends very much on the particular situation of a given investor in the area that they're in, the country they're in, what type of relationship they have with the state. If there is a contract, for example, a concession or something, then they might well be looking at that. And it is, as I say, it's a concept that's recognized in international law, but I think it's more likely that it would be looked at through the lens that Guillermo was mentioning of police powers, or alternatively that you'd be looking at states in attempting to invoke the state of necessity, as Argentina did when it in relation to its own crisis with the peso. And that would be many of the analyses in each national law system as well. There are different definitions of how force majeure works and what precisely it means. That would be something that would also would be looked at in relation to the actual concession in question, I think.
Yeah, but very shortly, I think along the same lines, it's the problem with defenses such as force majeure and also I think this applies to necessity defense, is that they have the challenge that they present is that they have it's a very high threshold in a way, so very specific conditions for those that have to be met, and Article 23 of the LC articles contemplates all of those conditions. Perhaps if there's a candidate for such an argument in the current bundle of situations around the globe, I think this pandemic could perhaps be a proper candidate, because it is an unforeseen event. It has a really dire consequence. It has also it can be argued that it caused an irresistible force, and also that it's beyond the control of the state. So several of the discussions that you have in state of necessity defense, some of which we covered, for instance, the causation discussion, whether the state contributed or not to the actual situation, which then put it in a state of necessity, which was a huge part of the Argentine cases discussion, would not be present here. It would be quite unlikely to have an argument that some of the states, perhaps as the US had it at the beginning, China would be in that situation, but at this point it will be really overreaching to assert causation to any of the states. So maybe force majeure in this case could apply. It certainly has imposed very dire conditions upon states, and states have had nothing to do with it, right? So it could, I think it could be argued in this case much more, even if difficultly, but much more than in almost all other situations which make force majeure really hard on international public law.
There is also the possibility that a state would argue, or rather that the not the state, but the investor would argue that the state has assumed the risk under Article 23. The state, one of the exceptions is the state assuming the risk of that situation occurring. And so you might argue, I'm not saying that necessarily would work, but you might see a situation in which a claimant would argue that the state assumes certain risks in terms of public health emergencies, and that there should have been better provisions in place, and so on and so forth. Whether that argument would work, I don't know. You'd have to look at the very particular circumstance, and then you'd be also looking at proportionality, what states generally do, are you supposed to have enough hospital beds to cover X or Y, blah, 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 blah. Very specific proportionality arguments would be applied. And maybe if the state tried that defense, someone would try to invoke Article 23. B, I think it is, which is the 2B about the assumption of risk.
Exactly, or that the state measure itself or failure to take measures somehow contributed to the severity of the crisis.
Yes, which is, I think that's our 23.2a or something, which
Yeah, whatever
it kind of echoes a bit the necessity argument. I mean, it can't be the,
yeah, it's 23.2b. Yeah. And but just a comment there, and of course we are arguing here, and it's rather funny as it were. We are being very cautious of putting all of our propositions in hypothetical terms, because really this is a matter that can be and has been threatened to be possibly litigated in the Council of International Investment Arbitration. But what I would say that also this situation poses, which is specifically and legally interesting, is that you have, unlike the necessity cases related to crisis, where the crisis is very specific. It's specific to a country, to a context, to a time frame, to certain measures, certain people. This is a crisis that has gone all over the board by now. It's worldwide. So you have a lot of comparable experience. And thus an argument that could go in the direction of saying, well, you should, if you would have perhaps adopted this kind of measures, then you would have prevented this kind of facts happening, which could indeed be posed, I agree with that, would have a difficult time being upheld. I think this is of course all speculation in terms of you being able to pinpoint to other states having adopted some of those measures, and by doing so having avoided the consequences which your state, which in this case didn't foresee. And given the fact that this pandemic has hit, I think, all countries around the world quite similarly in terms of debts and economically, both liberal and socialist, both more developed, less developed states, I think that line of reasoning gives rise to a kind of discussion that we have not quite had before in international law, certainly not international investment arbitration.
And you make a good point that this is really not only a health crisis, but it's really an economic crisis and a human crisis. So you can think about different measures targeting different effects of the pandemic and being analyzed under different frameworks, as you suggested, under the proportionality framework. But it's certainly going to be a very interesting discussion, and we might end up in 10 years with an Argentina-like body of case law on these issues.
I'll jump right in. Considering all that was said here, we have a question from the YouTube. Marina Muniz, she asks us if we believe that investment arbitration tribunals might be more inclined to accept state necessity or force majeure or regulatory powers arguments presented by states due to these contexts. Don't know if we're entering in futurology here, but I'd like to hear your thoughts on that.
My view is that it will probably go back to the specific treaty language in the first instance, and that tribunals would look carefully at what exactly the state's commitments vis-a-vis the investors are. And from there, I think it's quite difficult to predict how tribunals will analyze the issue. But I do take Alex's point that you would have to look at, the content of the measure, the context, the timing, and the effects of the measure, and even the conduct of the investor to give a holistic analysis of the issue. And, as both Guillermo and Alex suggested, proportionality could be a framework that tribunals adopt to analyze the issues. But at this stage, I don't dare predicting the outcomes.
Yes, and I think I agree with what Clovis said, and they will go look very specifically at the precise measure in question. It's the existence that this is an emergency. I don't think anyone would disagree. There is an emergency, but it's what states do in response to the emergency, that there has been significant variance in how states have responded. And you've had from very extreme responses to laissez-faire responses. And each of those, arguably, the severe responses have led to businesses being closed down and dying and failing. The laissez-faire attitude, arguably, has led to people dying. And so there could be consequences either way for businesses, for claimants, potentially. So you need to look at each measure and then what the state's response was, because is that a police measure? And also, more importantly, if it is is it a police powers measure? If it can be defined, depending on what the treaty says or what other definitions are applied, then you're going to be looking at the key question of compensation, because it's, again, the real point here is not so much the existence of an emergency, but what else the state could have done, whether its measures were proportional, and is there something specific in the treaty or whatever that allocates the financial risk of that, because it will either go that the state was entitled to do that, sorry, no compensation, or alternatively, there would be a right to claim at least compensation. And then you'd be looking also at the question of when the crisis ends. I think that's the other key piece of the analysis, because when the crisis ends, then then different rules would apply.
Just one additional issue on the question that we received. Of course, I would also be cautious about predicting the outcomes, both for professional reasons, but also because it is always hard to predict the outcome in legal areas across the board, but in particular in investor arbitration. And we have not had, as I was saying, cases I think quite comparable as this ones in the past. But what I would add, to try to be adding a precise issue that I think would loom large in these cases, is the uncertainty situation from a scientific point of view. So when you are conducting a proportionality analysis, which would play out whatever the difference is invoked, it is relevant whether what the state had in mind and what kind of research was done and what kind of analysis was performed before adopting or before choosing which way to go. And what I think it's quite beyond dispute at this point in time, almost a year into the pandemic, is that there's still not, and certainly was not, available any knowledge at the beginning of the pandemic in terms of scientific knowledge, of just knowing what to do, just knowing what kind of virus we are facing, just knowing what prevention avenue is or is not more effective. So I think this might end up being discussed more in the field of something along the lines of the precautionary principle, which is typical, for instance, environmental language, to use Alex's expression, which I liked. And because in cases of uncertainty, which this one is particularly one of those, I think that's quite undisputable, it should, a quite extended margin of deference should be at least seriously considering, because maybe what we know now or what we will know a year from now was certainly not what the state knew or could have known at the time, being that there still is no scientific consensus about what is it that we are facing and how we have to do it. And I think, again, this is something that, of course, was discussed in prior cases. Again, in the Argentinian cases, for instance, there was discussion as to economic theory and economic policies and how the enactment of one of those would lead to one of other results. And even if there was uncertainty there was a much more robust body of literature which could support one or the other position. In this case, I think it will be really hard to support the position that states knew or should have known what they were getting into when they adopted one or the other measure. So for most measures, I would say all of those that were not radical or erratic or in other way just non-reflective, if there was any, I think the lack of scientific consensus would be a major technical part of the analysis.
Yeah, the foreseeability of the measure would certainly, of the pandemic would certainly be an interesting discussion as well.
Also, yeah, I agree with that.
Okay, I think you can move on to the next topic. That's exactly to discuss also the effects of this pandemic, the treaty making in international investment law. As we are aware, in the recent years, there is some discussion concerning treaty making, mostly regarding the maintenance of regulatory powers for the states, some carve-outs to for the protection of national interests, environmental and health concerns as well. And well, I believe this current context of pandemic might add something to this fire as well. So for this topic, I'd like to call Mr. Guillermo Moro to discuss his view on this issue. Guillermo?
Fantastic, thank you, Orlando. And I will try to be particularly brief on the topic, but also because of the timing. I don't know. I know we typically can entertain discussions, for as long as they take, and I'm willing to do so, by the way, today as well. But and in terms of the organization, I don't know whether we should have any time consideration, because there's also one other topic in charge of Chloe's presentation. I would not like to detract time from her presentation. Should we have any time constraints or considerations by now?
We have the floor at least 9 p.m. So we can just go into the discussion. If you feel that there is still time to go to the last topic, we can move to the last topic as well. But I don't think that I think that if we conclude with we take the time to discuss the first topic, and leave the last topic behind, it's not a problem.
No objections from me.
All right. All right, fantastic. So great. So the perspective of this third topic, which was proposed by the organizers, is quite different from the one we were considering up to now, which is we were talking about the within so there's already treaties in place, and then there are parties invoking and interpreting provisions of those treaties, and tribunals deciding, and states and investors alike interpreting those before adopting the respective conduct. Now we are invited to think about what impact, if any, the current pandemic could have on treaty making, right? So what lessons can be learned? What is this teaching states regarding, and stakeholders in general, regarding how to negotiate and draft investment treaties in the future, or perhaps about not doing so. So I think that discussion can be organized through three different avenues. One is what the impact of COVID-19 can be in the process, and I'm sorry, in the purpose of concluding investment treaties, then in the process of concluding those treaties, and finally in the content of those treaties. So as for the purpose, what I refer to here is that the COVID-19 has had, among other consequences, and Chloe picked up on this a couple of minutes ago, economic consequences, right? And those are, for some states and stakeholders, those are the main issues. Some put them before the actual life of people. So then I wouldn't go that far, but certainly these are very important consequences of the pandemic. So, and again, one aspect of this economic crisis is the huge backlash in terms of the flows of foreign direct investments. And there has been recent reports by United Nations and the monitors of foreign direct investments that are being done quarterly, which have shown almost 40 to 50% decrease in the foreign direct investment flows. So we are talking about a huge impact in terms of foreign direct investments. So this could lead states to actually add a new and perhaps quite strong reason towards concluding bilateral investment treaties. Actually, there have been some reports, for instance, in one of the main treaties that is being negotiated at the time, the China-US agreement, where the pandemic has been considered a boom, has been considered an impulse towards the conclusion of the BIT. So my point here, or the question of remark that I would take from this first avenue of analysis, is that we should be wary about going into or states going into concluding BITs for reasons related to an emergency, right, such as this one, without weighing sufficiently the pros and cons of doing so, as states would do in say normal situations. And that is because states could be persuaded by the notion that concluding these kinds of agreements can be part of the set of measures urgently needed to invigorate their decreased economies, right? So the pandemic could have an effect in terms of adding to the purposeful attitude of states towards signing BITs, and the question mark should be perhaps put there in terms of whether that is or is not a good impulse, a good motivation towards that institutional decision, which will continue to be in place after the pandemic ends, if at all, as we hopefully hope that will happen soon. Hopefully decided that will happen soon. So next, the second line of analysis is the process. So just as the pandemic has impacted the ISDS process, that is the actual conduction of investor-state arbitrations, and that might be something that we can perhaps touch upon before concluding this conference, in terms of the submission of memorials, in terms of the hosting of hearings, execution of awards, etc., production of documents. There's also a challenge posed to states in terms of the negotiation of treaties, right? And there have been several reports in ongoing negotiations of those negotiations being stalled, certainly not getting to the point of subscription because of the challenges of remoteness posed by the pandemic. So that is a second impact on treaty making that I think the pandemic can have. And third and lastly, perhaps the most important part of this analysis is the substance. What, if anything, does the pandemic teaches to states and stakeholders in general in terms of what provisions they should or should not include in treaties that are being negotiated or can be negotiated in the future? And here I would perhaps select just two of the points that I have for time's sakes. The first, a chapeau, or a very general remark. It is international investment arbitration teaches, perhaps unlike any other field of international law, that it is particularly important for the parties subscribing as a treaty, in this case states, to take all measures necessary to get what they actually want in the treaty. Because after the treaty is signed, the treaty is going to be interpreted and applied as if the states actually took all those measures and took all the time to reflect about the inclusion and exclusion of each and every word of the treaty. This is something it's a canon of international interpretation, international law interpretation. We can discuss it, we can agree or not with it, but it's part of the language, again, of the repertoire of the arguments in international law. So it is quite important for states to take good care of that. And the history of drafting and subscription of bilateral investment treaties shows that states have not been typically aware of the consequences and the importance of each of those words that were included in the treaties. And this can and sometimes is part of arguments about how to interpret those. But I think now, after all these decades of practice and decisions, it is quite unforgivable for states and stakeholders to not consider those consequences in drafting the treaties. So with that being said, two issues. One, the pandemic could be located within the framework of, first, the right to regulate, and within the right to regulate, the right to regulate regarding health issues. So in all those second generation and third generation treaties which contain a specific provision on right to regulate, typically environmental and health issues are already there, right? So a first reaction could be, well, there's no need to contemplate anything different in this case, because if there's any case in which we have a clear health issue being posed, well, it is the case of this pandemic. If not this case, well, which case? And it is hard to disagree with that idea, but this sort of fast agreement with this notion could have a paradoxical effect of pushing in a direction that state parties to treaties would not like to push, the threshold to analysis, of the analysis of the right to regulate for health issues. Why I'm saying this? Because even if it would be, I would say, very hard for tribunals to condemn states for cases of regulation vis-a-vis the pandemic, for reasons such as the ones we were covering before, that could move the threshold much farther away for other cases in which the discussion of health is had, one could say the normal cases, right? Which even if states get not considered to have breached international law in the context of the pandemic, the mere fact of that discussion happening within the right to regulate for health reasons can have the paradoxical effect of making the threshold lower for other cases in which in normal circumstances health issues are discussed. And this is certainly something that seems to go against the trend of tribunals being considerably different to states, both in environmental and health issues in international investment arbitration. And again, I'm pointing to this just from the perspective of this being or not a desirable consequence for state. If it's an undesirable consequence, then perhaps the pandemic shows that this kind of massive, unforeseeable, and harsh situations regarding health could be regulated specifically, separately in the context of treaties, so as to distinguish them from the general framework of health issues in normal situations. So that's, I think, one possible discussion regarding the COVID effect on COVID effects on treaty making. And then the second and last one that I would like to put on the table and for my colleagues and the public, as it were, to discuss is actually what is treaty making? That is, what can we do with the extant treaties, both first, second, third generation, whatever generation of treaties. And perhaps you could say, well, that's a different question, because the topic that Orlando proposed is, what's the impact, if any, on treaty making? But I think there's an interesting question to be raised here as to what is to make a treaty. And so the formal, I would say, traditional way of looking at it is to say that making a treaty is negotiating its term, subscribing and ratifying it, right? But that might not be quite correct, because what a treaty actually is depends not only on the negotiation of its terms, not only on the terms of the subscription and ratification, for instance, if there are reservations, but also on how it is interpreted and applied. And if at any point in time there was an unforeseeable circumstance that sort of brings tension in what the states wanted to protect, the protections the states wanted to give through investment treaties, is the case of this pandemic, right? And so what can states do vis-a-vis those kind of unforeseeable situations? Well, international law contemplates this situation. And this is actually being discussed in Group 3 of UNCITRAL as one of the one of the 5 or 6 main topics for reform, which is the interpretation of treaties by state parties, right? And that is also a part of state parties to treaties being in control of what they want that treaty to mean, right? And this is something that is contemplated in Articles 31.3a and 31.3b of the Vienna Convention, okay? In terms of first joint declaration or interpreted declarations by state parties, and then the actual practice of state parties. I don't want to delve into that discussion now. We can do that because it would take quite some time. But I'm just pointing to the existence of these tools, which, particularly if exercised by states outside of a particular litigation context, because when they are exercised, and you were mentioning Alex's involvement, I don't know whether Alex is involved in any of these cases, in the Colombia cases where there has been some declarations by the US, and the NAFTA cases where there have been declarations by the US, Canada, or Mexico quite often. And so, irrespective of those cases, outside the context of actual litigation, states have the opportunity to just state what they actually meant, for instance, when they granted certain provisions vis-a-vis an unforeseeable, so worldwide harsh situation such as the one posed by the pandemic, right? So it is not necessary to stop the analysis of treaty making in the negotiation table. Treaty making goes a long way afterwards. One way in the courts and tribunals, but also in the interpretations that treaties, that state parties to treaties give of the terms. And of course, I'm not trying to blur the line, and that is another very interesting discussion between treaty interpretation, which is what is envisioned by Article 31.3 of the Vienna Convention, and treaty making, because it would not be contemplated by those articles to remake ex post facto the terms of the treaty under the guise of an interpretation declaration. But it need not be that the case, right? States can, vis-a-vis this unforeseeable situation, perhaps take the opportunity, or at least analyze the opportunity of jointly say what they understand the treaty to mean, if applied to a very, very specific situation such as the pandemic, and particularly if done outside of the context of actual litigation, that I think could be quite interesting in terms of the construction of international law by states in terms of protection of investments. And I think that's another teaching of the pandemic situation for states and stakeholders in general in terms of treaty making. I think I would conclude my remarks here so that we can have some more minutes to discuss, and particularly for Alex and Chloe to jump in. Thank you.
Yes, Guillermo, on that last point you made, that there is a key distinction between interpreting a treaty and redrafting or amending the treaty. I would argue that to the extent that the treaty parties can and are able to provide these joint interpretations of what they intended, that interpretation must be consistent with what an investor would have expected the provision to mean, given that, theoretically speaking, that investor is a third-party beneficiary of what would be that treaty and is entitled to rely or has actually relied on the terms of that treaty in making an investment. So I agree with that key distinction that you draw between interpreting and amending. And I think it's a very key distinction.
Yes, what contributes to clarity and consistency is good. What looks like moving of goalposts by states, after all, this is the investors, who are also stakeholders in the process, do not have the power to say what they think it means, except by bringing a claim and asserting a claim that interprets the treaty in a particular way. But clarity and consistency are important. On that, the question of whether people should move quickly to, I don't think that it makes sense to suddenly change treaties overnight, or change them, or to negotiate new treaties just to preempt certain situations that may or may not emerge. We don't know what will happen in terms of COVID investor state cases. There will be some, there may be a whole wave of them, there may be just one or two. We don't know about that. But I think that it's important to look, as Guillermo pointed out, there are already rules about what states can and can't do in terms of reasonably responding to situations, emergencies, exercising their police powers. There are countervailing requirements for reasonableness, proportionality, non-discrimination, which is particularly important. You can only talk about these things in relation to specific measures in order to ascertain whether it was reasonable, proportional, and necessary for that specific measure not to be taken. States will do what they have to do. They will close a factory down, they will stop people leaving their houses if they have to. Is it reasonable and proportionate? That's a different question. They can do it and they will do it. But the reasonableness and proportionality issues go to when we're sorting out the mess afterwards, what is to be done, and whether the state was acted reasonably, proportionately, and so on in exercise of its police powers. The treaties may or may not be adequate to cover those particular circumstances. I think we'll only see, you only see these things when, 5 years down the road, you look back and you go, well, this happened, this worldwide emergency. There were then a number of cases about particular issues. The outcome of those cases was as follows. Either, you might find that the states were found almost entirely to be in the right, and that compensation, well, that question, I don't want to predict how it will go, depending upon the question of how states exercise their powers, etc. Only then will it become apparent to all the stakeholders, states in particular, the ones who have the power to decide that they want to renegotiate treaties or to negotiate new treaties with new provisions. They'll only see whether that's reasonable once they've looked at these cases and gone, well, we didn't think that we were getting into a situation where we were automatically required to do X in terms of, if we did institute emergency measures, then we had to do the following to protect investors, and that wasn't what we imagined. So we're going to, think differently about our treaties going forward. You only really know that not now, but after the claims have emerged, and preempting it with too rash an action would be, I think, foolish and unnecessary, especially because, to a large degree, some of the movements in terms of treaty negotiation and new generations of treaties have already preempted this type of situation. And I don't think you can be too specific about what you're doing, because really these cases are not about can a state take measures or not, but again, about a very specific situation. Was that measure in that circumstance against that particular claimant, was it or was it not a breach of a treaty or some norm of international law, given all the circumstances on a case-by-case basis? And those are situations that you cannot always just regulate for in advance. You have to, states have to act reasonably, and investors have to look at the situation and then decide whether or not they think that there has or has not been a breach of a particular treaty.
And I would only add that the third generation treaties that Guillermo mentioned seem to already be taking account of those developments, and perhaps we'll see further changes in that direction. But I tend to agree with Alex that, over-regulating is probably not.
So everything was foreseeable then. That we could get into a long discussion about that then, but I agree with you. Yeah.
Yeah, it's I think that's something I wanted to raise as a question. I think it's really hard to have an answer to that. And I think that those are very good points. But just very briefly on that, I think the fact that states have the power to evaluate what they actually meant in the terms of the treaty, all state parties, right? Where there's an interest of those states to protect their investors, particularly in those cases, in those states that have more presence of exporting capital, as it is typically said. I think that's a control on the against the partisan reading of these kind of exercises, trying to be preempting strategically or trying to rush into doing something to prevent some suit to be brought. I think that's completely beyond the kind of processes that are envisioned in the Vienna Convention on Interpretation of Treaties. And the fact that states do these kind of things jointly, I think, provides a rather robust control towards those partisan interests, which typically would not be shared by those two states. And then also as to the not going into over-regulation, for the interest of discussion, right? and I'm not sure I would agree with that. I think actually one of the problems of in the sense of not being too specific, I think one of the problems of investment, of the legitimacy of investment treaty regimes has been that the normative source of that is the bilateral or regional investment treaties have been perceived by states by virtue of not being too specific to simply contradict many times what they actually intended to put in there. If they are more specific, if they learn from experience and they actually say what they say, as of course I'm not trying to confound treaties with contracts, but typically in a contract, you get to be completely specific, which doesn't mean that you can envision all kinds of situations. Because you can't, we exist as lawyers, right? But most situations are being contemplated and specifically regulated. And I think it is interesting for treaties to gravitate towards that direction in terms of being specific and to contain what states actually want to say, for instance, when they refer to damages, rather than have just a very broad discussion and not including any kind of precision, and then ask that regarding anything else in the treaties, unless treaties states actually want not to be specific and just say, well, we want to have a very general provision so that our investors can debate this before a tribunal, and a tribunal will decide in the context of a specific dispute. Fantastic. What I think it's important is for states to actually look into that and take a conscious decision in terms of what they want to do and what they do not want to do. And I think being specific should be at least an option for states and that they consider. So, right, that's just to perhaps foster discussion.
Just before concluding, we have a new question on YouTube. This is the final question from Luisa Engers, one of our viewers. Greetings, everyone. How's the relation between the ITs and human rights treaties in the arbitral jurisprudence? Do you believe that the amicus curiae influence might grow stronger? Or maybe considering this current scenario, can we maybe consider that there might be an increase in amicus curiae? Any of you want to give your thoughts on this question?
Go ahead, Alex.
No, go ahead. You go ahead.
Or perhaps Chloe, you want to take the lead?
No, please go ahead.
No, I mean, I think what I have to say first is that this is a quite broad issue, and it might need to be discussed in more time than the one we have available. I don't know, Octavio, Orlando, Mateus. It's a very good question, certainly, but it's so interesting that it needs for a lot of time for assessing it. I would just say that that interplay is still under construction. Actually, the Vienna Convention on the Law of Treaties have something to say in that regard. Also, the reports of the ILC Commission regarding the fragmentation of international law and the interplay between the different regimes. I think very interesting things can be said about this, including the fact that sometimes human rights regulations enter international investment regimes in a different way that people advocating that introduction typically argue for. That is, they enter international investment jurisprudence as further protections for investors rather than as explanations of the conduct of states, because in a way, human rights are also rights granted to individuals against the state, just as investor state rights. But there's lots of things that can be said. Regarding amicus curia, it might be the case that these kind of situations, if a claim is brought and taken before a tribunal, it would be perhaps quite difficult to imagine that amicus curia would not be allowed. But then again, you could say that perhaps of several other kinds of disputes. I'm not sure this specific one would be more welcoming of those kind of submissions.
I would also add that, for example, the new Dutch Bilateral Investment Treaty actually recognizes the OECD principles on business and human rights and makes them part of the treaty context, even though they're not actionable as treaty violations. I would say that that's a new development that we're seeing in the so-called third generation treaties, that human rights are being more discussed and addressed in this context. And of course, like Guillermo says, I agree that this is an area of development.
Yes, I'd agree with that too. I think it is increasingly common to see amicus briefs being filed. As you have more transparency in bilateral investment treaty arbitrations, it's something that comes in. There is always the question of the relevance of that particular amicus brief to that particular claim, because the difficulty is what are you claiming for something? What relevance does your intervention in a human rights context have on that particular case? It can cut both ways. States can be violators of human rights. They can invoke human rights as a reason for their actions. I think that is wrapped up. Defense of human rights can be wrapped up in a state's justifications for its actions. It depends, and that can be a valid or sometimes an invalid invocation, depending upon the particular case in point. So, and amicus briefs can be helpful in that regard, and sometimes they can be off beam or not particularly relevant to that particular issue, but it is becoming more important to bear these issues in mind. And a criticism made of the general world of bilateral investment treaties is that precisely because there have been so many cases, it's rather like an arm that you exercise one arm with exercise and not the other. That one area of international jurisprudence to do with investments has become very developed, with a lot of cases about all sorts of issues, but not so many cases that link human rights protection with those particular investment issues. Not always easy to do, but I think you will see those issues being addressed more in cases as we go forward through amicus briefs or through the briefs of the parties on either side, states or investors.
And I would only add that, the right to property at the end of the day is a human right protected by investment treaties. So I do see many areas of intersection, and I think those will grow stronger moving forward.
I think that's a perfect spot for me to jump in. And I think we've discussed you know, where we came from. We've discussed where we are now, living through the pandemic and the effects that, you know, this global health crisis is having on contracts and on investments, and, you know, already undergoing in future disputes. And we briefly touched on, you know, where we're going and where, you know, you each think, you know, where treaty drafting will lead and is going, and how it was impacted and how it is impacted by COVID and, you know, the situation that we are facing now. I think it's quite interesting for us to sort of adapt the foreign experience to our local market. You know, in Brazil, where we're not signatories, but we are sort of players in this international scenario. And of course, I think, you know, ending with this perhaps amicus curiae discussion is perfect, because it sort of raises a number of different issues in which each of you, you know, each of your propositions and discussions will come very handy, and is already an excuse for us to have another webinar to discuss, you know, the procedural aspects where, you know, we ended up not being able to get at. And of course, amicus curiae faces and poses a number of sort of material discussions, but also procedural discussions, and the limits of the participation of the amicus curiae in the proceeding, and how, you know, how far can it go, you know, what are its limits, and how effective can it be. You know, just before we leave, perhaps I would invite each of you to sort of give a position, perhaps on how we sort of in Brazil should, you know, what we should take from the international experience of investment arbitration, and perhaps even more specific of, you know, these discussions that we dealt with, you know, in terms of proportionality, non-discriminatory, you know, sort of avoid abuse or you know, bad faith interaction with contracts, you know, how we should perhaps learn from this experience and learn from the experience that you are now having during, and you expect to have after, if, you know, we are to have an after of this global health crisis. You know, very briefly, if you could just, you know, in your closing remarks, we would love to hear your, you know, impressions. Clovis, perhaps you want to go first?
What can Brazil learn from the international investment system? That's a tough question, but I don't see anything. I think being a player, a strategic player in the system, has been good for Brazil. You know, Brazil has entered into these new treaties with state-to-state provisions, and I'm curious to know what's behind that move, and whether it signals you know, an intent to engage more with the international investment system. But I would just say that, you know, take what it's good and be smart about any treaties that the country will enter into if Brazil were to decide to move in that direction. Otherwise, my perception as an outsider is that Brazil has been a smart strategic player in the system.
Guillermo, Alex?
Look, I leaving Alex to conclude, what I would say is that Brazil has, one does not need to say anything, and whatever one says, of course, would not be relevant. But for the sake of the exercise, in terms of giving an advice or an opinion, I would just say that Brazil has to retain what it already has, which is to have an imprint, to be an actor that has an imprint. It has a position, specific, which is backed up for what we know. There's some empirical, sort of empirical in terms of soft sociology, as it were, papers describing the experience of Brazil drafting of these acordos. There's also some publications by officers and former officers of Brazil explaining the process. And so what literature shows is that Brazil has always and still engages with these issues with an actual concrete calculation of what it wants to get in signing these treaties for its investors and for its citizens as a state receiving investments. So whatever that path leads Brazil to in the future, I think the attitude, the channel of technical analysis and strategic political thinking is even exemplary for other states which are pushed somehow to the mainstream rules of how a legal treaty is drafted, what provision has to have, and what is it that you have to do in drafting a treaty. I think that Brazil shows that, well, you have to stop the ball, as it would say in Argentina. You have to think and say, well, what do I want to negotiate in this treaty and why? And then do it. But many countries do not seem to have that imprint. Of course, one that can derive from the relative differences in strength, economically and politically, that Brazil has vis-a-vis other countries. But say countries not so far away from Brazil in terms of economies, certainly as Argentina. You can see the late Argentina, after all these cases which we were referring to, again, during the last few years, committed to the subscription of BITs. 3 BITs, and then an investment protection chapter in a treaty of free commerce, free trade, right? So 4 agreements. They have not been ratified yet, but they're in the process of being so. And when you read them, you see them incorporating some of the teachings of the experience, but many other things have to be left off the table. And of course, that is not a critique of the actual negotiation. It's very hard to be there. You have to see the constraints, the instructions, the scope to move. I'm not getting into that. I'm just saying that perhaps countries such as Argentina and other countries in the world should at least aim at preserving for them the imprint of countries such as Brazil that have dared to do it differently. And I think that is a promising avenue, whatever it leads to.
Alex.
Yes, I think Brazil is a grown-up country that can decide to do what it wants for its own good. To date, I don't think empirically you could say that its decision to stay largely outside the ISDS system, because although it is a player, technically I agree, but on the other hand, it is not, because it's not directly involved in that system. It is not a major player, certainly not a player that the size of the country would normally suggest. So it's up to Brazil to decide what it wants to do. What will be interesting, I think, going forwards is as Brazilian state entities conclude concessions with arbitration clauses that will involve a higher, there will not be, ISDS, there will not be ICSID arbitration agreements and so on, but nonetheless, they will be concluding agreements with foreign investors where there will be an increasing number of issues will come up. It will be interesting to see how the whole international jurisprudence about complex technical issues that have arisen in many different circumstances, in many different cases, how that will play into Brazilian arbitrations, what relevance will be attributed to them, whether Brazilian law or tribunals applying Brazilian law, because there may be tribunals that are mixed with some international lawyers on them, to what extent that they will take account of the developments in international investment law over the last 2 or 3 decades. I'm very interested to see that. And I think it's a way in which Brazil can increase its involvement as a player, because I think Brazil has a lot, and the Brazilian legal profession, the Brazilian state and Brazilian investors, particularly investors, because they're the ones who could be actively involved, proactively involved in claims against other states. All of them would benefit from being more involved in the system to move it forwards in whatever direction they collectively believe is useful.
I think that's perfect, Alex. Thank you very much. I think that ultimately, as we've seen, the adherence to the ISDS is a road with no return. We've seen backlashes, but ultimately everyone goes back to it, and because of what it promotes and where it puts in terms of the right of property and sort of the protection of rights and contracts. Just a personal opinion. I think Clovis mentioned, why would Brazil, would always opt, to state provisions. I think ultimately is the role of state, and I think this sort of applies to other Latin American countries, but specific to Brazil, I think it's still very culturally entrenched, that the importance of the state in the private investments. If we look at the past few years, and especially in Lava Jato, we see that in every different market, the state had a participation, either in approving concessions, in all areas, construction, energy, banking, and ultimately, I think this is the state maintaining its, its sort of its reference in investment. Its role as a leading player in investment, even in a society where you have the impression that private players are free to act and free to contract as they wish. We still have a very strong state and a political influence in private investment, as we've seen in the past few years. Just to close, Orlando and Mateus, do you have anything else? Do you have any closing remarks? I'm sorry.
I would like to thank you again, the speakers, very interesting topics. We prepared another questions, but we are over time for a long time now. So in the interest of time, and I wish you a very delightful night. And I'd like to thank you again for attending our event today. Thank you.
Thank you, everyone.
Yes, I agree, really over time. And all I can say at the moment is really thank you for attending, for accepting the invitation to join us at this webinar. It really meant a lot. Thank you all, people.
Great.
Thank you.
Thank you. It's been a
Thank
pleasure.
If anyone has any issues that want to discuss with any of the panelists, they are very accessible person. You have their LinkedIn access. You can send an email through their firm's local email. And thank you again for watching. It was a pleasure. Alex, Guillermo, Clovis, Orlando, and Mateus, thank you very much, and have a good evening. Have a good night.
Good night.
You too. Good evening.
Thank you very much.